today to talk about police brutality. We have wonderful participation so far. It looks like we're up to 79 or 80 participating. My name is Steve Schwinn. Our panel today consists of Professor McMurtry-Chubb, Professor Ricardo, Professor Jones, and me. What we're going to do is take a couple of minutes and each say just a few words about areas that we've been looking at and are within our expertise, and react and chat with each other. But we'd like to open it up very quickly to discussion from participants. So we hope you feel free to participate. Miller McDonald is going to help us moderate the discussion. You can send questions to her privately if you like, or you can send questions to the group. We'll all keep our eye on the questions. If you'd like to use the hand raising feature in WebEx, you can do that as well. Given the numbers, I think it's going to be important that we either hand raise electronically or submit questions in the comments area, just so that we can moderate the questions and make sure that everybody gets an opportunity to ask or contribute what they would like. We very much would like this to be in the nature of a conversation and less a sort of expert talking heads panel. And so I hope that we're able to achieve that, and really to facilitate a discussion with you all. I'm thrilled that you're joining us today. Wonderful group of participants, and I look forward to a robust, interesting discussion. Just one thing before we get started, we are recording this, and so if you don't want to be recorded, you can mute yourself, mute your video and your audio. And again, if you want to remain anonymous, you certainly may do that and send your questions privately to Miller, and we can retain anonymity in that way. Okay, so we're going to go ahead and get started. What we've agreed on is that Professor McMurtry-Chubb would open the panel and say a few words, followed by Professor Ricardo, Professor Jones, and then I'll say a few words, and we'll open it up to a discussion and questions and answers. Professor McMurtry-Chubb, you want to get us started?
Sure. Can everyone hear me? So my purpose here is to kind of contextualize this discussion historically. Many times we start a conversation as if this problem began in 2020, but it's actually the root cause of the problem has never been fixed or addressed. And so it requires that we understand exactly the context that we're operating in. So my story begins with looting and rioting. The first looting occurred in the United States or the Americas with land and indigenous peoples. And so the goal of the European colonizers who came in was to kill them, to march on them. US military, state militias. Andrew Jackson was a violent killer of indigenous people. And what was the purpose of this? So that we could clear the land so that we can use it to make and produce things that would benefit the European colonizer at that time. So law springs up, a system of law to implement systems of property that serve the interest of capitalism. It's important to understand that this economic theory is driving the law. So we have Georgia land lotteries in the 1820s that are taking advantage of this newly cleared land of indigenous peoples, giving large parcels of land to European descendants who are currently in Georgia. This occurs throughout the South and the Southwest. And again, it was to clear the way for large-scale plantations, primarily sugar, rice, indigo, and cotton. And so what does this have to do with anything? Well, cotton was the major global export throughout this time. By 1860, the United States was the world leader in cotton exports. Why do we care? Well, let's back up a little bit. Remember, I told you the story started in looting and rioting, and we had more looting of 11 million people from the continent of Africa, different tribes and different cultures, to be the labor force in a system of generational enslavement, to work as forced labor. So as I said, many of these enslaved people were working on cotton plantations. By 1860, cotton made up 60% of the total U.S. world exports. And this is important to understand that this is a global imperialist capitalist economy, that the raw cotton was used in the textile mills of Lowell, Massachusetts, that it was used in the textile mills in England, which made England a global producer of cheap cotton fabric, which would be important for the fashion industry. And it fueled the shipping industry in the North. We have ports in Manhattan. You wonder why Manhattan is the economic center of the United States. This is where it begins. Slaves were traded, enslaved individuals were traded as commodities at Wall Street. New economic instruments popped up in order to facilitate the system of forced enslavement and large-scale cotton production. So we have slave mortgages, we have slave insurance, all of these instruments, insurance instruments, mortgage instruments pop up around the slave industry. And what does all of this have to do with policing? Well, this whole system, this whole global economy was poised on the ability of slave owners to control and surveil Black bodies. So at some point, the technological innovation of the cotton gin sped up cotton production. But the cotton gin alone didn't do it. You still have to get the cotton from the field to the gin. And how do you do that? You torture and you surveil Black bodies. There's a system called, it's been called alternately the whipping system, the pushing system, where overseers pushed Black bodies to the limit and made examples of those Black bodies. Men, women, and children worked alongside each other in the fields, no differentiation along gender lines. And enslaved individuals who did not pick their quota of cotton were tortured, killed, used as examples for other enslaved individuals so that they would keep up their productivity levels. There's this whole system of surveillance that arises in the South that empowers white women, children, and men to surveil Black bodies if they are not in their place, meaning on the plantation. So Ahmaud Arbery is an extension of this. He's running along the marshes in South Georgia where these plantations existed and where white women, men, and children would have been empowered to surveil him. And so there's this inherent right embodied in the customs and traditions of these states, as well as then enshrined in the law, that allow this empowerment, this understanding that it is the role of white individuals to surveil the bodies of Black people. So with the 13th Amendment, slavery and involuntary servitude become unconstitutional except as punishment for a crime. And so Southern states seized on that exception and built up their penal codes to recapture the newly freed workforce. And so prisons become the new site of enslavement. It's important to understand this. And this is a global phenomenon. We like to talk of this in terms of the South, but it's not. It fuels a global economy. Prison economy, the prison industrial complex is a global economy in which the United States is still the world leader. So as I mentioned, citizen arrest statutes borrow the language from these slave surveillance statutes that were enacted throughout the Southern states. And again, there is this understanding, this customs and traditions enshrined in our country that it is the right of white Americans to surveil the bodies of Black Americans. Policing happens everywhere, formally and informally. So I often, dealing with my students of color, particularly my Black students, there's always this hypervigilance about appearing in groups, no matter where we happen to be. We shouldn't be appearing in groups. We might look guilty. This is, again, the flip side of the DNA, right? We're not empowered to surveil ourselves. We're always conscious of how we might appear outside with others. We're constantly hypervigilant and walking around the city, walking in stores, understanding that we're being constantly surveilled. And again, I want us to understand that it's baked into the DNA of our country, and it began with the global economy of slavery and enslavement. Lastly, what I want to say is that this is what leads to the police deaths of men, women, and children, like Rekia Boyd in Chicago, where she is perceived being out with her two Black friends. Dante Servin, the police officer, shoots at the whole group backwards, ends up killing Rakia. Laquan McDonald, Tamir Rice, Breonna Taylor. I can go on and on and on, right? But this is the consequence of this. I want to say that, to conclude, that policing, if you put a large scale amount of police anywhere, you're going to find trouble. And that crimes are constructs. So when certain people do certain things, it's not a crime. When other people do certain things, it's a crime. Right. Hence my framing my remarks in terms of looting and rioting, because we don't see that the foundations, economic and policing of this country were built on violence, looting and rioting, but we denigrate when our populace in a cry of help does the same thing. So this is not, the system is not broken. The system is operating exactly as it is intended. So I will stop my remarks there. Thank you.
So Steve, I think I'll go next, right? Okay, great. Hi, everybody. Thank you, Teri, for starting us off. Can you hear me? No.
Yes, I can hear you, Kim.
Okay, are you?
Fantastic. So I just wanted to thank Professor McMurtry-Chubb, as well as the rest of my co-panelists. And I also wanted to thank behind the scenes Noor McDonald and Michael Huggins for the admin and tech support. Professor McMurtry-Chubb has laid down, I think, a really important base for us in terms of both theoretical and historical context around looting and rioting, also the economics and policing, which I think is really important. The work that she has done in terms of critical race theory and critical race feminism, I think is really important. I would encourage you all who are in attendance to take a look at some of her work around that. I think we see that although critical race theory and related sort of scholarship on critical theory, social justice, in particular race, has often been sort of criticized as not having to do with the law, right? Something outside and a part of the law, and devalued because of that. I think in these days and in these times, we see that the leadership and the thought leadership on issues of race, culture, and society have been led, number one, by lawyers, but number two, by critical race theorists. So I appreciate your work, Teri. I am going to focus today in my short remarks a bit more on sort of the on-the-ground stuff. And I'm going to talk about the criminal charges that have been filed against Derek Chauvin, and some observations that I have on the prosecutorial strategy. I'm also going to sort of frame that by talking about the power of the American prosecutor, as well as her electoral vulnerability, right? The majority of the United States prosecutors are elected officials. That means they are politicians, which also means, though, that they are subject to electoral politics and all of the concerns around getting reelected. I don't think I can underestimate, or I don't think I can understate, rather, the power of the prosecutor in our criminal justice system, right? And I want to keep in mind sort of three present things. A lot of stuff is going on right now. A lot of stuff has happened, and it's often sort of very difficult to keep track of information, and in particular, names of people and honoring their names. But I'm going to just, mention three things in terms of current sort of statuses, right? There are still no charges against the police officers who entered Breonna Taylor's apartment after midnight on a no-knock warrant and killed her. The charges against the two men who hunted down and killed Ahmaud Arbery only resulted after a video showing his killing surfaced, and there was public pressure to do so. The same thing followed the prosecution of the police officers in Minnesota who killed and participated in killing George Floyd. I think this isn't, the power of the prosecutor is something to keep in mind and is really important because although the prosecutor is endowed with a lot of discretion and discretionary ability, the fact that the majority of prosecutors in the United States are elected officials is really significant in determining what power the public has in participating in the criminal justice system, at least at the prosecutorial end, right? So now I want to talk just kind of briefly about the actual charges against Chauvin in particular related to his killing of George Floyd. Initially, Hennepin County prosecutors charged Chauvin with 2 homicide charges, right? Under Minnesota law, 3rd-degree murder and 2nd-degree manslaughter. Now, for those of you who have taken my criminal law class, right, you will know that every state has its own criminal code and defines its crimes in different ways. But for our purposes, because Minnesota has used the common law, I can sort of reflect on some of the stuff that we learned about in terms of the common law approach to crime. 3rd-degree murder in Minnesota is more or less what we would call depraved heart murder. 2nd-degree manslaughter, these are again the 2 original charges, amounts to what we would have called under the common law involuntary manslaughter or the killing of another person through negligence, right? The thing about these charges is Minnesota law is actually, the criminal code is actually really arcane in that depraved heart murder under the common law, I think, would be a strong charge. But in this case, it is not. Why? Because of Minnesota law. While Minnesota law generally follows the common law in talking about the depraved mind state in terms of killing, it also limits the theory of depraved heart murder in a strange sort of way. In a series of cases since the 1980s and just recently reaffirmed in 2017, the charge of 3rd-degree murder or depraved heart murder is not appropriate when the defendant's reckless actions were directed at a specific person versus at sort of an indistinct group of people, right? This is the reason why 3rd-degree murder under Minnesota law doesn't seem to be a good charge. Several days later, Attorney General Keith Ellison filed and added another charge against Chauvin, that for 2nd-degree murder. 2nd-degree murder in Minnesota or under Minnesota law is, you know, essentially what we would have called felony murder under the common law. But the predicate offense for which the prosecutors are basing the 2nd-degree murder charge in Minnesota is Chauvin's physical assault of George Floyd, right? By putting his knee against his neck for 8 minutes, felony upon which this felony murder charge is based. As students from my criminal law class will know, the majority of jurisdictions around the United States, this is not sort of the fact that the predicate felony is an assault would sort of prevent the charge from moving forward because of the merger doctrine. That is, because the predicate or underlying felony was assaultive in nature that led to the death, normally the prosecutors would be forced to prove murder through a different sort of theory, whether that be intentional or depraved heart murder. As I've discussed, depraved heart murder, although it's still sort of in play here, does not look like the appropriate charge. I think we see that pretty clearly in the aftermath of the prosecution of another Minnesota police officer for shooting another unarmed person on duty. Mohamed Noor was prosecuted for both third-degree murder and second-degree manslaughter, as well as second-degree murder for shooting and killing a white woman, Justine Rushak, while he was on duty. He was acquitted for the second-degree murder charge, but convicted for third-degree murder as well as second-degree manslaughter. He filed just about 2 months ago, an appeal and a motion for new trial, arguing that there was insufficient to hold him or to convict him for third-degree murder, citing specifically Minnesota law that specifically excludes from the depraved mental state the idea that a person is specifically targeting an individual with their sort of reckless behavior. So the sort of questions raised around the different charges and the sort of complexities about Minnesota law recall to my mind a few years ago here in Chicago, the prosecution against Dante Servin for killing Rakia Boyd. In March, for those of you who are unfamiliar with the facts, in March 2012, off-duty Chicago police officer Dante Servin was driving around his West Side neighborhood after midnight when he spotted a group of young Black people walking away from a party. An image that Professor McMurtry-Chubb has talked about, right? He was in his luxury vehicle driving around the neighborhood and was upset apparently because of the loud noise coming from a public park. He approached in his car this group. They walked away from him. He was upset, and as they walked away, he drove away, but shot 5 times involuntary manslaughter. Involuntary manslaughter under Illinois law is defined as essentially the killing of another person with recklessness, right? I think it's really important to note that although we seem to be in sort of a new period, in terms of the sort of prosecutorial perspective, those charges against Servin were the first time in 15 years that a Chicago police officer had been indicted for a fatal shooting, whether off or on duty. What happens at Servin's trial is really mysterious in the sense that although he was prosecuted for involuntary manslaughter, after the prosecution rested its case, Servin asked, like almost routinely all defendants do, for a directed verdict. Instead of denying that motion for directed verdict, the judge in that case, Dennis J. Porter, awarded that directed verdict. Why? So here's the important part. Remember, the original charge was involuntary manslaughter on a theory of recklessness. Manslaughter, importantly, not intentional killing, right? Again, it was the first time in 15 years that a police officer had been indicted for a fatal shooting in Chicago. There were certainly reasons, I'm sure, why Anita Alvarez decided to go for that manslaughter charge instead of something else. But the judge in that case awarded the directed verdict. Why? Because he said that Servin had acted intentionally and not recklessly. And we repeat that because it doesn't make sense. He awarded an acquittal in the involuntary manslaughter trial of this former police officer. Why? Because his acts were intentional, not reckless. This is a result that doesn't make sense in the law, nor sort of under any kind of logic, right? The Illinois Code is based on the Model Penal Code. And as any of my first year law students will tell you, recklessness is a lower sort of level of mens rea. Intent is baked into, that is, recklessness is based in intent. Or rather, let me sort of reword that. That is, if the prosecutor can prove intent, otherwise known as purpose under the Model Penal Code, then they can certainly prove recklessness. The Judge Porter really turned this on its head by sort of ruling in the opposite way. I'm going to stop now, sort of in deference to my colleagues, but I think it's important to note at this point, before I leave you, that as prosecutors are elected, so are the majority of judges in this country, and Judge Porter is up for re-election in 2023.
So, Steve, I'm gonna go ahead and get started. I want to. Is there any problem hearing me? Let me just confirm everybody can hear me as well. Thank you. Thank you. I am very thankful to my colleague and friend, Professor Schwinn, for inviting me to speak today. I do not take this invitation lightly by any means, although African-American males are disproportionately affected by police violence, and that research indicates that no other group in the United States is more affected by police violence and police brutality than Black men and boys. Very rarely do we have the opportunity to share our experiences and present our research or lead discussions or even participate in discussions of this magnitude or of this light. So I am very appreciative to have the opportunity today to be able to speak with you a little bit about my research and what I'm doing, and to offer some thoughts and engage in conversation about this. This is a very important issue to me. I've been writing and researching about police brutality and police violence for quite some time. As many of you know, my work on law enforcement problems is well documented and quoted a lot around the United States. My piece, White Power in Law Enforcement, which was a study of the way in which white supremacists have infiltrated law enforcement and the threat it presents to the United States, has been something that has been talked about for quite some time. My latest work, Police Heroes in Child Trafficking, which was published in 2018, was my attempt to address the alarming number of police officers who are engaged in sexual violence. And although we are talking today about police brutality and excessive force and that nature, I do want to say that I recognize that there are an alarming number of people, namely women, who are victims of law enforcement sexual violence, children, people who are engaged in sex work, undocumented workers, people who are in police custody, who find themselves victimized by police officers. And I stand in solidarity with them as well. And I stand behind the Closing the Law Enforcement Consent Loophole Act of 2019, which is an attempt to ban in the United States all police officers from engaging in sexual conduct with people in their custody. So I'll make my comments short, and I'll just advise you that my comments today are just a small fraction of the comments that I'll be giving tomorrow morning at the University of Michigan on this very topic. I'm very honored by their invitation as well. But one of the things that struck me by my colleagues' comments was when Professor Ricardo said, "It doesn't make sense in law." And she's exactly right. And the other thing that I hope that you all picked up on is the comment where it says the system is operating the way it is supposed to operate. And one of the things that I would invite this audience to do is just ask yourself one question. Is there anything that happened to George Floyd that hasn't happened last year, in the last 5 years, in the last 10 years, in the last 20 years, or in the last 50 years? Okay? And so I asked that question because one of the quintessential duties of the attorney, of the law student, of those who study the law, is to understand the predictive nature of law and what it means for something to be law. And law, if it is not anything else, it is a system that is that is allowed to sustain itself through prediction. That is, that we can deduce what is going to happen in the future by simply looking at social conditions and application of rules and laws, interpretations of rules and laws today, and as they have been interpreted and applied in the past. The second thing I would ask this group to think about as you consider the problem of police brutality and police violence is to think about what it means to be part of a system of law. And what does that system look like? What does it entail? For instance, we've just heard about the prosecutor. There's no question that there is a serious problem with prosecutorial misconduct in this country. And I would submit to you that the riots and looting that you all have seen in recent times are not simply the result of the police officers' conduct, but also the results of the alarming comments that the prosecutor made after witnessing the police officers' conduct, which suggested that he thought that they might have been innocent. And so law really is a byproduct. Law really is a collaboration. Law really is a system that involves the prosecutor, but it also involves judges and the decisions that they render. It involves the jury, who are oftentimes armed by bias and prejudice. It involves the evidence, okay, which typically is distorted by police officers giving defective testimony, a common behavior known as testifying. It's also influenced by the work of the medical examiner, who refuse every day, every week, to put forth a good faith effort to analyze and describe how a person actually died who happened to be in police custody. It is also the product of who is the injured party. Is the party an African American, or is the party a Caucasian? Is the party Hispanic or Asian? Okay. It is the product of interpretation. How do we interpret the authority of the law? How do we interpret the discretion that police officers have to use force? Okay. But one of the things that we oftentimes don't think about is that we also are a product of the law. That is, that we look at police violence as if the police are exacting some sort of violence or doing things that have not been authorized in most part by the American people. And many of us engage in that authorization every day when we fail to speak up. We engage in that authorization every day when employers see their employees on social media making racist statements. We see that in law schools all around the country. When people address criminal law and criminal procedure without talking about widespread problems within the system, or talking about the problem that we're talking about today, police brutality. We see it at the dinner table when police officers come home, when their violent conduct and their conduct are embraced by their loved ones, their sisters, their brothers, their spouses, their parents, and sometimes their children. And we also see it in our nation's schools when resource officers are exacting violence against our children, mainly in communities of color, and very rarely these things. Rarely do we ask ourselves, how is it that Black men can represent 6% of the population, but nearly half of all inmates? and Black boys can represent 6% of the population and yet represent probably about 35% of people involved in special education, or why 1 in 3 of them will wind up in the criminal justice system. In fact, one of my colleagues mentioned the other day that we have more Black men involved in the criminal justice system than we had slaves. And so when we talk about police brutality, it is very important to understand that this is not a problem that is new. It is something that we have been able to predict for quite some time. It does not make sense in the law if you look at the law in terms of its how it is enunciated on the books. Of course it doesn't. It doesn't make sense, right? But again, it is so important to understand that the law is simply not what is on the books. It is a product of everything I just talked about, the testimony of the investigators. We can look at what happened in Tallulah, Texas, and plenty of other examples of people who are innocent people who were jailed for crimes they did not commit. There's been a number of studies that indicate people of color are innocent people of color are 12 times more likely to be wrongfully convicted than whites. And in a recent study of about 1,800 people who were found to be innocent, the overwhelming majority of them were African Americans who were convicted and framed for drug offenses and framed by police officers. And so we have a very serious problem in this country with respect to police violence and police brutality. I would very much like us to think about the way in which so many people, so many parties and institutions perpetuate and allow this system to sustain itself. So I've been spending my time collecting data on many of these things for quite some time. Many of this, the data and research is reflected in my various works and comments, either in radio, TV, whatever. And I'm always happy to share those, but I'm more interested in answering your questions and engaging in this conversation. And so I again, am very thankful to be here and welcome your comments and questions. Thank you.
Thank you, Professor Jones and Professor McMurtry-Chubb and Professor Ricardo. It is just such an honor and thrill and pleasure to discuss these issues with you. I hate that we have to discuss them, but I can't imagine 3 better friends and colleagues to discuss them with, and I look forward to engaging the participants in Q&A. Let me talk just a couple of seconds about what I've been thinking and writing about with regard to police brutality and trying to look at this at a constitutional level and a kind of systemic level. I think about some of the impediments to holding officers to account and holding police departments and municipalities to account, and indeed even holding we the people to account for what's going on in this country. And these are not just incentives or not just impediments to preventing police brutality, but incentives that actually systematically incentivize police brutality at a structural level in our system, and I think we need to address them. We can think about these at 3 different levels. We can think about them at the individual officer level. We can think about them at the department or community level, and we can think about broader system-wide efforts and reform that we might look to that can help change the incentives for police action. So let's start and talk just a second about at the officer level. One of the things that we've been hearing a lot about in the news recently is this doctrine of qualified immunity and looking to change qualified immunity so that officers can be civilly liable for monetary damages for their constitutional violations. I can say more about that if you're all interested in it, but it really has been all over the news. I've done some writing on it myself. And I think that's an important component of reform, but it's certainly not the only component of reform. That just scratches the surface. When we think about at the officer level, we can also think about criminal liability, not just civil liability for their acts. And Professor Ricardo and Professor Jones, I think, did a fantastic job sort of setting out the landscape with regard to criminal liability. In addition to the things that they said, I just want to add that the federal statutes on criminal liability for police misconduct are extremely difficult to enforce. Federal statutes on enforcing civil rights laws against officers are extremely difficult to enforce. But these are things that we can reform. And looking to congressional action, these are things that we ought to be looking to reform. At the department level or the community level, we can think about liability, but again, there are incentives, but again, there are some impediments to this kind of thing. So, for example, with regard to municipal liability for civil rights violations, it turns out that it's really hard to get a municipality on the hook, on the financial hook, for an officer's constitutional violations. That turns out to be exceedingly difficult, but it need not be so. We can make a change to make that easier. Another thing that we're hearing a little bit about this in the news, is this idea of consent decrees between the Department of Justice and local police departments. Many of you know that the Chicago Police Department is under a consent decree that started in the Obama administration and was modified. The Trump administration has made the judgment that it's not going to enforce these consent decrees and not enter into them in the future. And it's done this in the name of federalism and local control. Now, I guess what I would say as a systematic kind of measure, as a structural measure, that's exactly the wrong call. The federal government is empowered through our Constitution, the 14th Amendment in particular, to enforce federal law and force local municipalities and state governments to impose conditions upon their police and impose requirements upon their police so that we can hold them to account for this kind of behavior. At the biggest level, at the systemic level, there are some things that we're talking about as a matter of policy that I think are really important, looking to a national database, for example, of police misconduct so that police can't hop from one department to another without doing a thorough background check on their prior behavior. We're looking at adopting federal standards for use of force by police officers, something that Congress easily can do. It's well within congressional authority, and they ought to have done this a long, long time ago. We're looking at some problems of reform with regard to, the practice of internal investigation that police themselves largely, and that's an impediment to holding police to account for misbehavior and violence. And quite frankly, police unions can sometimes be an impediment. So looking at how we relate with police unions, I think, is an important component of this. Telescoping out yet even further, I'm just going to say one more word. Voting is so important. And Professor Jones mentioned how we can this is really all of our responsibilities to use not only our voice, but also our vote. But here again, we're seeing, with regard to both voice and vote, we're seeing a kind of disparate enforcement in a way that makes it very difficult to change. So with regard to the recent demonstrations around police violence, we saw police actually crack down on demonstrators in a way that quite clearly violated their First Amendment rights, among other things. But when armed militia stormed the Michigan Capitol because they didn't want to socially distance, the police simply stood down and stood back. What's the difference? Well, in one context, we're demonstrating in favor of Black Lives Matter. In the other, it's quite frankly, a bunch of white people demonstrating because they don't want to socially distance. That kind of disparate treatment by the police is wrong and deeply, deeply troubling. It's got to change. We see the same kind of disparate treatment with regard to the right to vote. And we've seen even up to the Supreme Court crack down on the right to the vote in a way that has harmed, well, just quite frankly, harmed the Black and racial minority vote across the country and made it much more difficult for us to exercise our voice. But at the highest systemic level, it's really important that we make those changes through democratic means, and you know, those are changes that should have been made a long time ago. And these the most recent tragedies give us yet another opportunity to move in that direction. I think with that, I'm going to stop talking, and let's see if we can open this up and get some discussion going. Q&A or discussion. If you want to send through the chat or virtually raise your hand, we can recognize you.
Steve, this is Miller. I have a few questions if you guys are ready. So the first question is actually from Laura Darby for Professor Ricardo. And it is, could he be recharged and retried? And I believe it's in connection with the officer in the Rakia Boyd case.
Right. No, he cannot be recharged and retried because of the constitutional protection of double jeopardy, right? The prosecutor has essentially one bite at the apple when it comes to criminal charges arising out of the same sort of factual event. So no, double jeopardy protects Servin from being recharged.
Okay, the next question we had was from Professor Acevedo, and it's to all of the presenters. And he said, cell phone cameras and videos have shown a bright light on the extent of police abuse and police brutality. The camera has uncovered what I believe to be a serious and continuing problem in most Black and brown communities. What corrective actions, such as training, suspension, terminations, damages, do governments need to consider to address such widespread systemic abuse? And what can we do as individuals to affect change?
So may I start that? That's a great question. So first, thank you for that question, Professor Acevedo. The one thing I would do is point to the Chicago Police Accountability Task Force report that was, I think, published in 2014. And that report revealed a number of widespread abuses on behalf of the Chicago Police Department. One of the things they did was they looked at police shootings from, I believe, 2008 to 2014. And they found that of those 404 police shootings, that is times when police actually hit someone or killed someone as a result of firing their weapon, 74% of those people hit or killed were African-American, 14% were Hispanic, 8% were white. And one of the things that, and I mentioned that to say that none of those officers were even charged. Okay, and as Professor Ricardo alluded to earlier, it's been 50 years since Chicago police officers were actually charged. And in fact, the Jason Van Dyke, who was involved in the Laquan McDonald shooting, became the first Chicago police officer convicted of murder in roughly 50 years in Chicago. So how does this relate to your question? So one of the things that have been said for quite some time is that we have the cell phones and we have the body cams, and we need the police officers to turn those things on, and when they need better training and so forth. Okay, one thing, my response to that has been that is 100% true. We certainly do need the body cams, and we need police officers to turn those things on. But more importantly, we need to understand that we've had a number of reports like the Chicago Police Accountability Task Force that reveals glaring acts of violence against people, particularly in communities of color. We've had reports in Ferguson, Missouri. We've had reports in New York City concerning stop and frisk. And so for quite some time, government officials and the public have been aware of the alarming degree of violence that police officers exact against people of color. So that's one thing. So it's not that the police don't know, and it's not that government officials don't know. Now, is there a gap between the public's understanding and the police understanding? Yes, but there are a lot of publicly available reports. The problem we're having with police officers in these body cams is that police officers now have taken the position that, one, we can't keep the body cams on in order to respect the rights of the person who's being recorded. And two, they are maintaining possession of the footage and only releasing part of the footage that supports their narrative. Okay. So even though we have body cam and we're having surveillance, they are controlling the release of this information and not being held accountable when they refuse to release it or when they offer only a highly edited version of the footage. And I'll keep my answer short and just say the other problem that we're having with this is, we can turn right to the Laquan McDonald case, in which we had to fight for quite some time to even get that footage released. And even when the footage is released and you reveal not only is the shooter quite, guilty, the officers who filed oftentimes false police reports or misrepresented what actually happened, rarely are they punished. On the training question, I can tell you right now, there's been a lot of talk about implicit bias training and so forth. This is something that the director of the FBI called for several years ago. I can tell you right now that there's been very little indication and no concrete data that implicit bias training is having any effect whatsoever on the police officers who are engaging in that kind of training. And in fact, the commentary in recent times has been that no amount of implicit bias training would have prevented what we saw happen to George Floyd, in Minneapolis. But thank you very much for that question.
I'm going to take a stab at that question as well. Thanks, Professor Acevedo. I think, why is what's happening on the ground now in response to these most recent killings of Black men and Black women and Black trans people, why is it so important that people are out on the streets? Why is media coverage and keeping the media accountable for reliable and true coverage of the uprising and civil protests, why are those things important? Because culture affects law and law affects culture. And when we talk about the law, right, we often make the mistake, because we're taught to in law school, right, that the law is sort of this neutral, principled system. When we fail to recognize and point out the many ways in which, for example, racism, for example, sexism, for example, classism, impact the supposed neutrality of the law, we get really confused and we don't know how to understand how things are happening. In particular, when we're thinking through a situation like I'm sure we will see sort of raised in the Chauvin sort of proceedings, police officers, just like anybody else, right, are entitled under the law to raise self-defense as a claim, right, as a defense, an affirmative defense to homicide charges. This requires a police officer, just like anybody else, to establish that he or she had a reasonable belief that his or her use of force was necessary under the circumstances. Reasonableness seems like a really neutral concept to us, right? But it's not, right? How is reasonableness interpreted? Reasonableness is interpreted by our own biases and prejudices about the context and circumstances, right? Does a white woman in her pajamas at night in a dark alley present a threat of serious deadly force when the officer is a Black man and immigrant from Somalia, right? Those facts that raise questions about race and gender are absolutely implicated in the calculus of reasonableness. on the flip side, right, or looking at the case against Chauvin, does a Black man who has been sort of reported as a suspect in a crime present a threat of death or serious bodily injury to a reasonable police officer? I think that we have to ask ourselves questions about how race and criminality and dangerousness are all connected, and how that plays out in the legal arguments about reasonableness in a trial that sort of raises self-defense issues. So back to my original point, why are these protests so important? Why does the refrain of Black Lives Matter mean something? Why do we need to know this? Because our culture's consciousness, our public consciousness is changing. And though, questions that Dean Jones raises about implicit bias, right, and whether or not training about implicit bias is impactful and effective are certainly important questions, right? When we are forced, what the research on implicit bias training does show, right, is when we are forced and we are primed about our prejudices, because most of us think of ourselves as egalitarian and wanting sort of fairness and justice for all. When we are forced to look at our potential biases, explicit or implicit, right, that's the only time that we can correct them. And that's why I think this moment is so important. And that's why I think we're having this conversation now, right? And I think in a way that we haven't had before, even though unfortunately the stories seem to be the same.
Okay, if there are no other panelists that would like to address that question, I do have the next question ready. This question came from Tim Hazen, and he is asking, how do you combat the police code of silence and the thin blue line mentality when police unions are basically encouraging that mentality? And he also said that absent public outcry, there would be no charges brought for the murder of Ahmaud Arbery. How can we improve accountability and combat prosecutorial misconduct?
Okay, so let me just lead off, and I apologize because I told myself I was going to be a little reserved and try and certainly be respectful of my other panels and not, sort of talk too much on this panel. But I just get fired up talking about this stuff. Let me this union problem is a very real problem. So let me just say this with respect to, because that is a very good question with respect to the role of these unions and so forth and where we go. So Derek Bell, has something called, interest convergence theory. And it was based on the idea that in the United States, white Americans will really never really align themselves with the plight and suffering of Black Americans unless it served their interests. Okay. So in other words, unless it benefits you as benefits a white American, very rarely will white Americans support the initiatives or recognize the suffering or empathize with the plight of Black Americans, right? And I don't want to mischaracterize his theory, but that's my understanding of it. And I think what Professor Bell was saying at that time, as it relates to this, is that whenever there's any sort of civil rights movement, okay, whether there's really any sort of attack upon the bodily integrity of African Americans, our rights, whether we're talking about fair housing, whether we're talking about police brutality or the right to vote or anything, unless it benefits white Americans, rarely will the vast majority stand behind it. Unions, let's be clear, okay. Unions are a problem. But the reason why they wield so much power is because they contribute to the very campaigns of the prosecutors who are in office, who oftentimes will respond to these very vicious acts of violence against people in a very slow and in my view, incompetent manner. But what you see in response to this George Floyd situation, you saw looting, you saw protests, you saw the destruction of property, you saw things that affected the economic interests of the white populace, okay? And people will say, well, what's different about this? The looting and the rioting, okay, I would submit to most people, although I do not condone any acts of violence, the looting and the rioting, I think, is what got us here rather than any acts of empathy. And the unions were there. The unions are just as powerful. But just like those unions contribute to the prosecutor's office, so do these corporations. And so now you're starting to see employees fired. You're starting to see, you can get on social media and you'll see a lot of employees saying this person is no longer with us, or we're no longer doing business with this person. Why? Because their financial interest is being affected. And these corporations and these business entities are speaking louder than these unions are speaking. And they contribute more than these unions contribute to the sustainability of the legal system. And so one thing it is important to understand is that when Dr. Martin Luther King led the Montgomery bus boycott, okay, he was considered being a criminal. They were engaging in peaceful protests. They were not looting. They were just refusing to ride the bus, and yet there was still criminal charges levied against them of all kinds, right? Based on all sorts of precedents, they all dressed up nicely in legal documents. They have violated a number of different statutes and so forth. I'm dismissive of all of this, the entire body of law. But it was the fact that they continue to resist riding the bus, which had a very serious economic impact on the local white populace. So if you want to address the union problem, you have to start thinking about the financial incentive to do so. The second thing I would say with respect to this problem is this is exactly why many people are moving some jurisdictions are actually considering disbanding police departments and starting over. Okay, people are talking, and we should talk about the funding of the police versus disbanding the police and so forth. And I'm sure somebody will ask that question, but it is very important to understand that the role of these unions is a very critical problem. And oftentimes they are so intertwined with the political system that the only thing you can really do is reimagine how you think about law enforcement in your community and ask yourself, do police officers need to be involved in every aspect of American life? Do they need to be inside schools? Do they need to be at our park, at our hospitals and so forth? And from defunding, reducing the budget, the economic might of police departments, right? Which means also reducing those unions, then you start to reduce their power. And that's how you deal with that, in my view.
I wanted to address this question from a broader humanitarian aspect, which is that it costs all of us something to not remain silent and to speak up in the face of injustice. And it's no less for police officers. And sometimes the stakes are, many times the stakes are very high. So if you're thinking about a brotherhood or a sisterhood of police officers and you're thinking of the cost of speaking up, well, that can mean that someone doesn't respond to your distress call if you're facing imminent death in the field. So I just want, these are people as well. One part of my remarks I want to make are a story. So my in-laws are from North Georgia. My father-in-law was the first Black sheriff's deputy in the county where my husband grew up, and he was also the first Black police officer on the force in the county there. And his understanding of his role as a police officer was very different than his colleagues. And so he was recently given an award last year for his role in protecting the community when there was an outrage over violence done to the Black people in the community. And something he never talked about, but that was extremely important to his white colleagues and to the community. And essentially what happened is that the white police officers wanted to ride into this situation where people were upset and they were beginning to do protests and some rioting had occurred, and they wanted to sit on top of their police cars and in their pickup trucks, and they wanted to have shotguns and they wanted to have a show of force. And he said, absolutely not. Our role is to protect these people. And so he ordered that there be school buses to the protest scene, and he basically took everybody home. And he said, "Look, we're just going to pay for all of this damage out of the county treasury, and then we're going to fix the underlying problem." And when you ask anyone what will keep their community safe, and you ask them to close their eyes and envision what they believe would make their community safe, no one ever says, "I want more police officers." Let me be clear. I'm a prison abolitionist. I'm a defund the police supporter, and I do think we need to burn it down and start over. Because, as I mentioned in my initial remarks, policing is rooted in a system of enslavement that fuels a global economy. And you can't get clean water from a dirty well, no matter the color of the bucket. It's broken. It needs to be completely and utterly destroyed and built up from the bottom. And we need to think about what our communities want and what our communities need with respect to justice, and how do we deal with the underlying social problems that drive negative outcomes, whether they be health issues, public health issues, perceptions of criminality, all of those things. The other thing I would say in conversation with my colleague, Professor Ricardo, is that she's absolutely right in terms of how race and gender implicate how police. But I would also add that America has a very long tolerance for torture and suffering of Black people. I mean, I may be dating myself a little bit, but I remember, I was an undergrad when Rodney King happened. And, I remember thinking, oh, like we finally got this on video, like maybe something will happen. Well, 20 something years later and hundreds of videos later and the internet, and no, we can see it constantly, but it doesn't impact necessarily how we deal with it. And I think part of that, Professor Ricardo was talking about what has brought us to this current moment. And I think that because the world hit pause and we were all forced to actually look at it, that people who weren't invested prior to this pause now had an opportunity to see it in a way a busy world doesn't allow us to. So I think there are many moments that got us to this point. Also, we're in a time of extreme instability. And when you're in a time of extreme instability, you become receptive to things that you weren't before. I think people are experiencing a wide range, over what the numbers are, like 23 million people are unemployed at the moment, or some crazy number like that. It may not be that many, it may be confusing percentages, but you get my drift. That when you become vulnerable, then you can better see other people's vulnerabilities. I'll end my comments there.
Okay, the next. Sorry.
Miller. Let me just say, there was a component to that question concerning the blue wall of silence that I don't know that we addressed that. For the audience sake, I actually do address that in my article, Police Heroes and Child Trafficking. But I'll just say, just real quickly, it is a very pervasive problem, and the answer, in my view, lies with accountability for police misconduct. We really don't have a very good system of holding police accountable for their misconduct. The blue wall of silence is a particular problem. But one thing that you have to understand within the culture of police, and many Black officers have testified to this, the very problem, is that you could very well find yourself harmed or even killed by your fellow officers if you violate that rule. It is a very real problem within law enforcement, and actually within many paramilitary organizations, okay? This is the very thing that police officers have long time accused African Americans of. Well, you all won't tell us the truth, or you all won't file charges, or you all won't tell us what happened, so we can't do anything to help you, when they are the epitome of failing to talk about or disclose the misconduct of their brother and sister officers. But again, in my view, punishment for failing to report it remains the only way that you can do that, and that punishment comes from the prosecutorial office and so forth. So again, That's something that's in my work, but I thought that we should respond to that question. Thank you.
Thank you, Dean Jones. So the next question is actually for Professor Schwinn. And the person has asked to remain anonymous. And I think this is in connection with your introduction, but they're asking if you could elaborate for those of us not in the know about consent decrees.
Yeah, I'd be happy to. Thanks so much for the question. So in reaction to a spate of incidents of police violence and unlawful killings, including Rodney King that Professor McMurtry-Chubb mentioned, and I'll date myself, I was in college at the time too. In response to those, Congress enacted a law that allowed the Department of Justice to investigate local police departments, their practices, and their history of police violence, and then to enter into these consent decrees with local police departments that then would be enforceable in federal court. And so the way this would work is the Department of Justice would identify a local police department that has a history of violence. They would go investigate, and they'd work with the department to come up with an agreement that the department would comply with and move toward a culture of nonviolent policing. Now, what the Obama administration used these to great effect and had a number of these consent agreements in many of the cities where we have seen police violence in recent years. The Trump administration early on, when Jeff Sessions was Attorney General, made the judgment that they were going to scale back considerably and effectively eliminate these consent decrees and not enter into new ones. Now, here's where we can talk about some structural features of our constitutional system that reinforce and actually incentivize police violence because of the way our Constitution has incorrectly been interpreted and applied. When Jeff Sessions said, we're not going to enter into these consent decrees anymore, one of the reasons why was because he wanted to leave policing to local control. He wrote this in his memo. He saw it as a federalism issue, that the federal government doesn't have the authority to go in and tell local police departments how they're going to police and in that way investigate and enforce a consent decree. This was a federalism issue. But Jeff Sessions' version of federalism, which is so much in the discussion these days, has no business in our discussion. It turns federalism on its head. The framers of the 14th Amendment adopted the 14th Amendment for the precise purpose that the federal government would enforce civil rights against states and local municipalities like police departments, for example. The framers of the 14th Amendment would be turning in their graves if they read Jeff Sessions' memo that said we shouldn't do this because of federalism reasons. Now, if we telescope out and talk about not just police consent decrees, we can talk about a whole array of federal civil rights where we see a particular brand of federalism working its way into the kind of policy and constitutional discourse so that these laws are interpreted in a way that the federal government doesn't robustly enforce civil rights against the states. As an historical matter, that's just wrong. As a constitutional and legal matter, it's just entirely incorrect. It turns our constitutional system on its head. So to see the federal government now saying that they're not going to enter into and enforce consent decrees against local police departments because of federalism issues, it makes my brain hurt. And this is the kind of power that the framers of the 14th Amendment actually envisioned that the federal government would have to enforce the protections, equal protection, due process, other constitutional rights against state and local governments, including police departments.
Thank you, Professor Schwinn. And actually stay with me for a second because the next question is also directed towards you. I believe we had two questions on this topic. I think one came to you, but another one came to me from Ryan Mitchell. And he's asking if you could please comment on the doctrine of qualified immunity and why SCOTUS is reluctant to address it.
Thanks for. Let me say just on this. We've been hearing a lot about this in the media, and I don't want to overplay it because qualified immunity is a piece of the puzzle, but I think a very small piece, and it certainly contributes to a sort of systemic incentive structure that incentivizes police violence, but solving qualified immunity alone will not solve the problem. So qualified immunity is a defense that a police officer can assert against a civil rights claim against that officer for monetary damages for the constitutional violation that the officer did. What this means is that an officer would be personally liable for the constitutional violation that they committed. The Supreme Court has invented this doctrine of qualified immunity that immunizes officers if the constitutional right that they allegedly violated was not clearly established at the time of the violation. And the way the courts have interpreted this clearly established requirement is that the officer's conduct has to basically be on all fours with an already established constitutional violation. Well, you can imagine how absurd that is, right? Each officer's action, each officer's constitutional violation is different in small ways than other constitutional violations that we've seen in the past. And in that way, qualified immunity operates, in fact, as virtually an absolute immunity for civil damage liability against police officers in these civil rights 1983, so-called 1983 claims. There are some proposals now kicking around to do away with qualified immunity in Congress. The Supreme Court had an opportunity to reconsider qualified immunity in a number of cases that came before the court. The court said just this week on Monday that it was not going to reconsider qualified immunity, that the upshot is that if anybody's going to do it, Congress has to. And Congress does have the power to do this, and Congress ought to do it. They ought to have done it a long, long time ago.
Thank you, Professor Schwinn. The next question is from Lashana Darling, and it's to the all panelists. And she is asking, she says, the Louisville Police Department claimed the murder of Breonna Taylor is still under investigation. However, the report was released indicating there were no injuries. How is this acceptable? It doesn't appear they plan to charge the officers for the murder, but are there other charges they can face?
I'm not familiar with the report, but this is a common, thing. Professor Jones alluded to it with respect to medical examiners. Excuse me, I had a temporary blank there. With respect to medical examiners and how they choose to investigate a case. We saw this in Mike Brown, where the medical examiner literally showed up with no batteries left in their camera, which is completely ridiculous, right? I mean, they forgot to put batteries in the camera, and that's part of their job, to take pictures. And we saw early reports released in George Floyd that said, oh, well, we don't think that a knee on his neck was the cause of death, right? So this no injury thing, I don't know, you haven't seen the report yet, but this is part and parcel of how these cases tend to go. It's so usually the family has to pay for, someone pays for an independent medical examiner to come in and do an alternate report or things like that. So it's not over. We're still putting the pressure on Say Her Name movement, making sure that Black women who are killed by police, who are also killed disproportionately with respect to white women. I think the statistics are often skewed because many researchers want to compare Black women to white women. That's not, Black women to Black men. That's not the correct comparison. Black women are disproportionately incarcerated, killed, police with respect to their white women counterparts. So we're still, across the country, still putting pressure on with respect to finding out what really happened. So this report will not be the end of an inquiry.
And if I could just add to that, one of the question was, could they be charged with something else? I would submit to most people that, and one example of this might be the Sandra Bland case. I would submit to most people that while the officers may not be charged with murder or excessive force or inappropriate use of deadly force, you can always look at their police report and find some discrepancy between what happened and what they actually reported. So if there's a genuine interest, okay, in holding the police officer accountable, all right, you can simply hold them accountable for perjury or for filing a false report or for dereliction of duty. There are a number of things that police officers do, sometimes as a result of poor training, but sometimes as a result of the culture of being privileged to lie or to tell the untruth, right? Or to hide or conceal the truth. So there are a number of ways that we can hold police officers accountable for misconduct and criminal conduct.
Thank you, Professor Jones, or I'm sorry, Associate Dean Jones. Our next question comes from Professor Mock, and it is to all panelists. And he is asking, clearly laws that exist today and has for centuries is badly flawed. Are there any comprehensive projects, perhaps university-based, that aim to produce a body of federal, state, and local legislative proposals, regulations, and procedures, which could serve as models with credibility for bringing about change? Is that something where UIC, led by UIC John Marshall, could make a big difference given the expertise and intellectual resources we have?
So first on the, I'll go first if the panel, if you all don't mind. On the federal part of that, right now, we have a big problem with the lack of federal data concerning police use of force. It is just mind blowing, and I actually agree with former FBI director of the FBI on this point. It is mind blowing that we simply do not keep data, as the federal government does not keep data of the amount of times and the circumstances that indicate when a police officer used deadly force in the United States. Okay, we need to track when police officers use force, when they draw their weapon, when they fire their weapon. If the U.S. military could do it, police forces can do it. So we certainly need to track police of use of force at the federal level. We also need to track at the federal level police misconduct. We do not track or identify, at the federal level that is, we do not track police officer misconduct, which allows police officers to be fired from one police department and to get a job in another police department. So you're fired at one in one city, you go 3 blocks away and you get another job right away. We saw this problem reveal itself with the killing of Tamir Rice. That police officer had been fired from one police department and wound up getting a job at another police department. We have simply too many officers who are unqualified to be police officers, but because we don't have a federal database to track police officers who have been fired when they lost their license in one jurisdiction, they're able to go get another job somewhere else. We also need to do a better job of tracking white nationalist groups and white supremacist groups, all right? The federal government, and there's been a number of federal findings in the last several years that indicate that these groups present a larger threat to our national security than foreign terrorist organizations at this point. But yet we do not track these groups and there is no federal database that any American could go to track these groups. We need to track these groups. We also need to see the extent to which they are infiltrated and become police officers, as well as prosecutors, judges, and whatever the case may be. So at the federal level, the last thing we certainly need to do at a minimum is keep a database of every person who is killed by a police officer in the United States of America at the federal level. We do not do that. So right now we have a number of private organizations, non-government organizations who are tracking various types of information. I think even the Washington Post has its own database. So when you ask about the role of universities like the University of Illinois, UIC, and so forth, one of the things that they can do is, or I might say we could do, is that we can track that information. If the Washington Post can do it, then we can do it. It's just that simple. All right. We also have the ability to authorize the creation and development and sustainability of clinics. We have some of the best clinics here in the United States of America, in my view. And this would be a remarkable opportunity for our students to be involved in this kind of data collection effort. All right, so that we also can do that. We also have to do a better job of tracking information related to those who have been wrongfully convicted at the federal level and why they've occurred federal level. And when I'm mentioning all of these tracking, I also am mentioning demographics, race, and age, and gender of both the police officer and the injured party. So I don't want to take time away from my fellow panelists, but that would be my thought on that question.
One of the things that Dean Jones mentioned earlier was Derek Bell's theory of interest convergence, right? I happen to think that racism hurts everyone, injures everyone regardless of race, right? Obviously, in many different ways, but just as a matter of sort of financial interest, right, which is another way that people are injured. The city of Chicago during the time period of 2011 to 2018, each year spent no less than $44 million either paying out settlements or paying for the legal fees to defend police officers in misconduct cases, right? No less than $44 million and upwards of $125 million each year. That's a huge amount of money that can be redirected and invested in other ways in terms of community development, education, social services, et cetera. Professor Mock's question was, what about the sort of research that's going on elsewhere? My colleague Cynthia Lee at George Washington University in Washington has done a really sort of thorough job over the last few years investigating this question, which I think is really key throughout the law, in criminal law and procedure, absolutely, but throughout the law, this concept of reasonableness and how that question of reasonableness is understood, constructed, and litigated, and also decided by juries, right? And there was a question from Sean Cash in the chat earlier about the heat of the moment, being in a fight and using force, right? How does that play into a determination of reasonableness when a fact finder is sort of charged with determining, in a situation of a claim self-defense from a police officer, what about this, right? From my perspective as a police officer, I did believe that my life was threatened under the circumstances. Well, yeah, absolutely, right? In our legal system, although it's not sort of explicit in terms of there's no special statute that says police officers are to be believed also, when it comes to sort of litigating questions about these, police have almost a sort of super credibility in our system, right, when they testify. For years and years and years here in the city of Chicago, for a generation, police officers would take the stand and say, I don't know anything about police torture, when we know that for close to 40 years, there was a regime of police torture happening in the police that was sort of prevalent and known, not only by police, but also by prosecutors and judges. And yet people, police officers took the stand and were credited for their testimony about not having knowledge about these things, right? But I would point to Cynthia Lee's work on reasonableness in a variety of different contexts, in particular in the context of race and policing, and also in terms of sexual orientation and gender identity.
Let me just weigh in quickly, if I can, and reiterate something that Professor McMurtry-Chubb wrote in the chat. UIC is doing some fantastic work around all of these issues. I taught a seminar in the spring where we were able to draw on some of that work in the human rights work that we were doing in the seminar. And if a group of us wanted to get together and think about systematic reform in the nature of Professor McMurtry, I think we would be in a really good position to complement what's already going on at UIC's main campus and coordinate with folks there and really instigate for systemic change.
One of the things that probably could be mentioned is that I am aware of a study on main campus where a number of researchers at UIC are already addressing some of these issues. And so this provides a great opportunity for increased collaboration between the law school and researchers on main campus. And the other thing I will just say, not to take up too much time, but on the issue of reasonableness, I would just simply add that I am, unlike others, I really don't know if police officers have a misunderstanding of reasonableness. Because one of the things that's been very clear from those of us who've looked at these issues, police use of force, is that when they engage white Americans under circumstances in which they kill Black Americans, for whatever reason, they understand restraint. They understand, how to control their anger, when they should and should not use deadly force and so forth, all right? For some reason, that the way most of us, as Professor Ricardo alluded to, the way most of us think of reasonableness, that common understanding of reasonableness seems to find its way in that interaction between the police officer and the majority of white Americans that they interact with. It is only when they interact with African Americans and Hispanics that all of a sudden notions of reasonableness become problematic. Wait a minute, that doesn't sound reasonable to us. Okay, so I would submit to people that perhaps we don't have a problem with reasonableness as we understand it, because reasonableness is being aptly applied to many Americans. It's just not applied to some of us. And I would also say that with respect to reasonableness, when we look at stop and frisk, when we look at the traffic stops, okay, let's be clear. There has been an abundance of research that indicates that police officers are stopping African Americans and Hispanic Americans at alarming rates. Alarming rates. All you got to do is look at the Chicago Police Force, Chicago Police Accountability Task Force to find out, how alarming this is. But the research is clear. When they are stopping white Americans, you have to exercise some degree of reasonableness to even stop somebody, either to frisk them or to stop them in traffic. They are finding more contraband, more drugs, and more weapons on white Americans than they are African Americans and Hispanics, yet they continue to stop African Americans and Hispanics at alarming rates, okay? And so what this suggests is that the notions of reasonableness, I would say, is not really the problem as much as it is racial bias. And also, the last thing I would say with respect to reasonableness is we have to begin to think about how police officers are interacting with children and how the reasonableness of that policy in and of itself, and I'm using reasonableness in a different context here, but there's been alarming reports of police officers simply walking up to little boys, predominantly Black boys, and saying, well, lift your shirt. Not touching them, saying, well, hey, I'm not conducting the stop. I just told them to lift their shirt or whatever, looking for an opportunity or interacting with them and just for purposes of triggering or igniting some opportunity to find some criminality in that little boy's behavior and so forth. And this has, and we haven't addressed this here, but these kinds of interactions with police officers have a tremendous impact on the emotional and mental health of these people who are interacting with these police officers. We have not really addressed what it feels like to simply walk out of your house and feel haunted by the very people who are paid to protect you, which is how some Americans feel, namely African Americans and Hispanics. okay? And so there's a lot of forms of violence, both passive and active levels of violence that I think that many of us are not aware of. I can tell you right now, I have experienced police officers pointing and loading guns in my face simply because I'm in a conversation with somebody else and telling me afterwards, oh, I didn't know if you were a gangbanger or if you were a drug dealer, if you were armed or what. I just got a call, there was a disturbance somewhere. You know, I have been somebody who have had their car, you know, stopped in traffic and had a police officer search my car, toss my daughter's child seat on the ground, pull out my spare tire, search my engine and so forth on grounds that I have drugs in the car because a dog sniffed a tire a certain way, all right? And regarding Rodney King, I was a young military police lieutenant. I remember being at the mobilization station. And I remember being there when African-American soldiers were looking at me with funny eyes, with funny stares, because we were about to deploy to California, and they knew it in their heart, look, based on the video, that this simply was not right. All right. So many of the things that we're talking about resonate with me, not only as an academician, but very personally. And I look forward for us to have more continued discussions on these kinds of issues, not simply after another person is killed, but on a continuing and systemic basis.
We scheduled
the
1 o'clock.
1 o'clock, and we've
1:10. We could and should talk about these issues much more. Professor Jones, I think, makes a very good point. We need to be talking about these not only after an incident or incidents, but all the time. And so we have scheduled other sessions as well, one on July 8th, and we'll have other opportunities to engage around these topics. The Black Law Student Association has also done an outstanding series on conversations around all of these very important issues. So, for myself, thank you very much for participating. Panelists, it's been a true joy to work with you on this, and I hope we can keep the conversation going.
Thank you, Professor Schwinn, and the rest of my much.